was fatally beaten by another officer. Remember, there was a hung jury the first time around. That's why we're doing it again. Let's bring in a legal expert on this. Vinoo Varghese joins us, is a white-collar criminal defense attorney and former prosecutor, Harvard Law visiting faculty. Welcome. You know, we've talked about this case a lot on and off, and now we're back to on because it's developed in the second part, the defense. It's like the battle of the crash experts. Like the other day we were talking about how the prosecution had its own crash expert. So now the defense brings up an expert, okay? And they're battling over what the car was telling them, timestamps on phone calls versus what the car's time said. But let me give you another example from this crash expert. His name's Matt DeSagra. And he says that her vehicle, it's a Lexus SUV, the data does not indicate there was a collision, okay? They say that they found 19 events on her car prior to the event in question, and none of those events, according to his testimony, were triggered by a collision. Pretty much contradicting what we heard from the prosecution's experts. So how does the jury sort through this, you think?
Well, as a defense attorney, you want to argue that the tie goes to the defense, right? So if you have the prosecution's expert, you know, who's being paid either by the state or works for the state, and then you have the defense expert who's being paid, the defense can simply argue, look, disregard both of them, right? Or make it a tie. If you make it a tie, that means there's reasonable doubt. That means the prosecution hasn't proven its case. And look, that evidence, assuming it can't be refuted much by the defense, by the prosecution, is good stuff. And I think that, you know, in this case, one of the problems with the case is that there seems to be a lack of physical evidence other than the dent to her car. So with the lack of evidence, you know, the defense is going to hammer home reasonable doubt, reasonable doubt, reasonable doubt. And then on top of that, when you add in all the conspiracy and the fun stuff that has been put out there in the media about this case.
Yeah, not only lack of evidence, but just sloppy evidence collection, which we saw. We heard all about the first trial. This guy Proctor, the state trooper who was just a mess, has actually been fired. That was a disaster. But I thought when I heard, and it's funny, we're only hearing about secondhand or reading about it from people who were in the courtroom telling us about it, as someone was on the show the other day, that prosecution witness was pretty convincing and a better kind of presentation than we had in the first trial. They were talking about all the speed she was going and all this kind of thing. But this guy DeSagra says today, on the previous report submitted, quote, he doesn't do the math. He lays out that there was a 19.2 second difference, but when we apply that 20 seconds to the event, then John O'Keefe's interaction window becomes positive 6 seconds. In other words, when they're saying, oh, there's no time for this, or this had to happen at the exact time, to your point, this guy, he's trying to throw that into question. So again, bringing up in the jurors' minds, well, maybe it wasn't as exact as the other guy said.
I think that's a good strategy. I think, look, in a retrial, you have the benefit of hindsight and review. So for lawyers, have most of the witnesses have their testimony locked in. The really bad ones, the prosecution got rid of, but you know they can still be made reference to, and how this investigation was conducted. Why didn't it investigate the people in the house? I mean, there's a lot of good stuff for the defense to work with. And I think that the problem is you have a city like Boston with its police force and as a defense attorney, this is one of those cases where you're like, wow, I wish I had these kind of facts, right?
Right.
And,
but as a defense attorney, do you try to construct like a story? Sometimes I hear people say that. Is it important just to be like, well, what they presented, this might not be exactly right, just to raise doubt, or you usually try to kind of construct your competing story? That seemed to be what they did the first time. It was like, oh, it might have been those cops in the house.
Yeah, you need something, because the presumption of innocence is only true in theory, not in practice, because no matter how many times the jury is instructed, hey, don't draw any inference against the defendant for not testifying, they're all thinking, well, if she's innocent, why doesn't she come out and just talk, right? And like, it takes the most discerning, like the most, true to the Constitution kind of juror to say, no, there's no burden on the defendant.
That's funny.
It's hard
By
to
the way,
find
she
those
talks
kind of
plenty,
people.
just maybe not in court, but she talks. Does anybody who sticks a microphone to their face, she talks. But having her testify would be a totally different strategy, which I don't know. Think the defense will change much? Last thing in this presentation, I know, is it tough? Your second time around, I know that she wasn't not guilty, but the fact they got the hung jury, there was obviously doubt raised. Do you go with the same exact strategy usually, or you have to be careful?
So one of the deans of the criminal defense bar, God rest his soul, a guy named Jerry Shargell, who represented Gotti in the Discovery of the History Channel documentary about him, and they only convicted Gotti when they got him off the case. He was, a friend, and we got to try a case again. And he said, anytime you get to leave the courthouse with your client, it's a win. So whatever happens, if you keep getting a mistrial, that's a win for Karen Reed, because that means she's not behind bars.
Yeah, you could tell from that guy, Alan Jackson, that's how they felt. They had that in the documentary, again, and she participated in that. All right, Vinoo, interesting conversation on all this. We'll see how it turns out with the defense.